3236, and in particular the table at 3441.
Could you have those page numbers again, please?
Sorry, my lord, yes, I'm going too quick. 3236.
Yes.
And the table at 3441.
Thank you.
And they then point out that in their response to the UNHCR statement of the 26th of June, they point out at page 3217 in that response, I quote, "Rwanda strongly respects the principle of non-discrimination for any asylum seeker who demonstrates a well-founded fear of persecution on any ground will receive protection." And we do note, moving from the government to the Rwandan National Commission on Human Rights, they were asked about the treatment of non-Rwandans, generally not in this specific context, but they were asked about the treatment of non-Rwandans. That's the Rwandan National Commission on Human Rights. And they noted, see page 2636 for the interview note, I quote, "If there is an area NCHR has not received any complaints on, it is this one. Rwandan society receives everyone. Anti-discrimination laws in the Constitution. Discrimination here is a crime, has its roots in our history," and so on. And we also note that the details are disputed. I said that the first problem with the basis for this serious allegation was too frail to bear the weight placed upon it. But even at the level of the detail of those individual cases, there is a serious dispute, it appears, between Rwanda and the UNHCR. And the government of Rwanda has provided its own table of decision-making, as I indicated earlier, see page 3440 and 3441. And Rwanda has provided some explanation for those decisions. See, for that purpose, Armstrong at paragraph 89, page 2684, so paragraph 89 of Armstrong 2684, and see the government of Rwanda's statement of the 2nd of July last year, paragraphs 12 and 13, page 3206.
Could you give me again, please, the reference before 2684?
The reference before that was to 2636. That's the Rwandan National Commission on Human Rights, that one. 2636, my lord.
And I think you also referred to 3440 to 3440.
I did earlier on, and I was doing it again, as it were, but that's where the table of decisions was.
Yes.
Yeah. That's the nationality one, but my lord, yes, that's the answer, and we'll get to it when we get to the allegations of not understanding refugee convention law and turning people away at the airport and all of that. But it is to be noted in this respect, in relation to discrimination, I park for this purpose the issue as to whether or not it's a good thing or a bad thing in refugee convention terms, but the government of Rwanda notes in their response that the reason that people were refused or turned away was because of forged passports or deception. Now, whatever else that may be, that isn't an indication of discrimination. That provides a substantive reason, maybe a bad reason under the Refugee Convention, but it provides a substantive reason which is not discriminatory for the treatment of those individual cases. So the overarching point is that even at the level of the individual cases, there is a genuine question, back to the point that the Lord Chief repeatedly made, which is, how on earth is anyone meant to resolve these to any extent satisfactorily? So that takes me to the fourth stage. Those were the three core concerns I hope dealt with in relation to the decision-making processes, particularly of the RSDC. And that takes me to the final stage of the processes, which are the rights of review and the right of appeal. That are embedded in these arrangements. Just to take those through and give you the detail. I'm sorry, this is I said it might descend into a dull reference-giving exercise, but at least give you the main points as we go. Individuals will be notified in a language they understand of the right first to appeal to MENAMA, that's an acronym, against the refusal of asylum by the RSDC. So you go RSDC, internal appeal to MENAMA, first of all, and second, to the High Court, should MENAMA, on the internal review, dismiss that. And you get that process built in from you get that process in particular, first of all, flagged in a passage you've seen already in the process NV, page 2381, at paragraph 4.9.3. That's the provision that tells them that they've got to be, that provides that they have to be notified not merely of the refusal with the reasons in fact and law, but also that they're able to appeal it and providing an explanation how to do that. That's 4.9.3. And then you see asylum appeals dealt with in paragraph 5, which I'll come to immediately. But 4.9.3 is the start. And as you see, individuals then have the opportunity to make oral and written representations to MENAMA at an appeal hearing, and any legal representative would also have an opportunity to make submissions. See paragraph 5.1 and following on page 2381 if you have that still open. Can I ask you to cast an eye down that paragraph in its totality? So you'll see, so far as the High Court is concerned, that in effect the jurisdictional provision in the process NV is the one at 5.4, which I referred to earlier on. The court will be able to, that's the High Court in Rwanda, will be able to conduct a full re-examination of the relocated individual's claim in fact and law in accordance with Rwandan rules of court procedure. And for good measure, if you go on to the, if you go back to the MOU, which this is reflective of, and you go to paragraph 9.1.3 on page 2369, so 2369, I should have done this in reverse order, but 2369, paragraph 9.1.3 of the MOU, if a relocated individual's claim for asylum is refused, that relocated individual will have access to independent and impartial due process of appeal in accordance with Rwandan laws. And as Mr. Mustard pointed out in his Foreign Office statement for these proceedings at paragraph 13.1.3, page 2745, the Rwandan constitution itself provides for an independent judiciary. And my lords, it's to that topic that I wanted to come next. The Court of Appeal were evidently troubled by the independence and impartiality of the Rwandan judiciary. Can I give you the references, as far as that is concerned, to the 3 judgments in the Court of Appeal that deal with this part of the case? The Master of the Rolls dealt with it principally at 95, 100 and 104. Lord Justice Underhill deals with it at paragraph 217 to 222. And the key paragraph perhaps in that little section of his judgment is at 221. and the Lord Chief Justice deals with it at paragraph 513 through to the end of paragraph 515. It is to be noted at the outset in relation to this concern, as the Lord Chief did at paragraph 510, that despite the scale and range of concerns raised by UNHCR, it says little, if anything, of substance about this issue in relation to the High Court. It does not make any positive case that judicial independence, or lack of it, perceived lack of it, in effect flaws this internal Rwandan protection. The principal basis for concern on that front is the divisional court's judgment in the Netsirayu case, which starts at page 5849. And that is a very long decision of the divisional court in the context of extradition. And I'll probably come back to that, if I may, after the short adjournment. But it's a long case dealing with the possibility of returning to face trials of murder, individuals who were involved on, for this purpose, the wrong side of the tribal divide, as it were, in relation to the genocide and the difficulties that Rwanda experienced at that time. And so there was a very, very specific and special context which led to the concerns of the court there. And ultimately, my submission in relation to that case is going to be that even in relation to that context, with its obviously incredibly fraught context and a difficult set of issues because of the way in which history had played out, even in relation to that, the conclusion of the divisional court was not that even in the context of trying crimes of that kind, the independence of the Rwandan judiciary, as it were, was a busted flush and could not be relied upon. It was that because of the concerns that might be perceived to arise in that very special context, there was a particular and overarching need for there to be proper protection in terms of legal representation of individuals who might face those charges in the Rwandan courts if extradited, and those were not present. So that was in essence the reasoning of the divisional court in that case.
So were these Hutus accused of killing Tutsis during the genocide?
Exactly. So that's what I meant by the wrong side. I don't mean that in any way to be flippant, but you see the point. And we respectfully submit that that does not provide, even on its face, and even in accordance with its own reasoning, a basis in effect for discounting as non-independent the entire High Court of Rwanda. But there's no proper basis for that sort of finding or that sort of concern. As I say, it was a special context, and on its conclusions didn't reach that finding anyway.
Just to help me, how many judges are there in the High Court of Rwanda?
Don't know. Can I check?
Say the entire High Court of Rwanda, one could imagine 10, 50, 100.
Don't know. May I check and get back to you? I didn't mean that to sound.
Well, it does sound like that, but I just wanted to get some figures on it.
I'll ask and make sure I've got that. But the particular concern in that case is the point that the people who are alleged to have been involved in the genocide in that case, and the people who might be trying them and or the government, there were strong concerns about animus, effectively.
And the reference to the case, Sir James?
The reference to the case, it starts at page 5849.
Thank you.
I'll come back after the short adjournment, if I may, and just give you the relevant paragraph numbers so you can see exactly what that context and concern was. But there's no equivalent position here. There's no reason to suppose. It's almost like the point I made in relation to Othman earlier on, there's no reason to suppose that the government of Rwanda have got a bias against these claimants or would want their asylum claims to be rejected, or would in some way be tempted to reach a different conclusion on the basis that the RSDC or MINEMA or anyone else had reached a particular decision in a particular case. That appeared to be the core concern of Lord Justice Underhill, and we submit with the greatest respect that that's a fanciful concern. And indeed, it's a fanciful concern not least for the reason that the Lord Chief was interested in at paragraphs 513 to 515, which is that everyone concerned will know, because they are public, that this full-blown appeal on fact and law, full re-examination of the case on fact and law by the High Court, is one of the specific things to which the government of Rwanda has itself committed in the MOU and in the process NV. But there is no reason to suppose that the High Court will not do precisely that which one would expect them to do, and which the government of Rwanda has committed them to do, which is to look at the individual facts on their particular merits and to reach a view on it for themselves. That independent role for them, look at it for yourself, fact and law, is specifically a task and a responsibility conferred by their own government upon them. Well, that may be a convenient moment.
Yes, yes, certainly. We'll resume at 2 o'clock.
Great.
James.
My Lords, good afternoon. The answer to my Lord Briggs's question is 32.
Thank you.
Temptation to have no further submissions to sit down is almost irresistible at that point. My Lords, I wanted to take you, if I may, very briefly to the authority on which the lower courts were exercised, and it starts at page 5849. It's a judgment of the Divisional Court, Lord Justice Irwin and Mr. Justice Foskett. And I'm not going to take you through more than a tiny selection of this, but I hope that you will see from the passages I take you to that the summary I gave you earlier of how the court ultimately disposed of the matter was an accurate one. If you go, if you would please, to page 5916. 5916. You'll see the conclusions that they reach on the independence of the judiciary in that context. And I've made the points I've made about the context, I don't go back on that. Can I invite you, in fairness to all concerned, to read, if you would, 234, paragraph 234 to 240. Which is that little section setting out the totality of their conclusions on that issue. And sorry, just as you launch into that, 234, you'll see they're dealing with the conclusions of Senior District Judge Arbuthnot below, and probably all you need to show you what she decided in relation to that, which was a bit of concern, but neither one thing nor the other on independence. You might look at 233, which gives you the core of her finding. It just makes sense as the lead into those paragraphs.
And ICTR, sorry, what's the abbreviation?
Is that the International Criminal Tribunal for Rwanda?
Ah, thank you. Where do we finish reading, Sir James?
240.
Thank you.
You'll see the cause for concern in that specific context, but in the end, agreeing with neither of the more extreme propositions. They're not independent, they are independent. Somewhere in between, there is a concern. That was the view they came to with a bit too sanguine conclusion in 239. And the significance of that conclusion is then reflected in 240, where they say, and that puts added weight and emphasis on the need for effective representation under Article 6 with trial lawyers and so on, and that can't be guaranteed, effectively, was the conclusion. So that's what I wanted to say about judicial independence. I respect this, that there isn't a proper basis in the materials before the court, still less by inference from this case, that there is, as it were, reason to discount the High Court in Rwanda as a proper and effective safeguarding measure referred to and relied upon and provided for in the MOU in the manner that you've seen, and in the process note verbal, and that in essence the Lord Chief's conclusion on this issue is correct. I wanted to pick up two final general areas on the process and the sequence of the process of decision making in Rwanda, and one of them is legal assistance, on which as you know, the Court of Appeal and the majority were somewhat concerned. But can I pick that up? Access to legal assistance, we respectfully submit, is guaranteed appropriately and properly in the MOU and the note verbal. See, for that purpose, the MOU at paragraph 9.1.2 2369 is the page number, 2369 9.1.2. Each relocated individual will have access ... to procedural legal assistance at every stage of their asylum claim, including if they wish to appeal a decision made on their case. And then the detail of some of that is dealt with in the process note verbal at paragraphs 5 in part and then 7 to 8 in part. So 2381 is paragraph 5 of the process NV. And you'll see in particular paragraph 5.2, second sentence on page 2381. And 5.5. So that's relating, in effect, to Minema and the Minema review or appeal and the High Court appeal. And then...
Sorry, was the MOU dealing with the initial interview before the RDC as well?
Yes, but I don't think deals specifically with this. I'm not sure the MOU dealt with it other than in general terms. The process NV comes back to legal assistance, at least, at paras 7 and 8. So 5 deals with legal assistance and what they can do and what they're entitled to do at the stage of appeal. And the earlier stages are dealt with, I think, in 7 and 8. Well, 8 deals with legal assistance at appeal as well. But 7, you see. and so the Court of Appeal majority appears to have been content with the position so far as appeals to the High Court are concerned, for which there's a right to free legal representation. See Lord Justice Underhill at 239 and the Master of the Rolls at 95. And the concerns really relate to the provision of legal assistance at the administrative stages, pre-High Court appeal, and related to practical implementation, in particular the attendance of legal representatives at interviews and the ability of lawyers to make submissions to the minister. But the conclusion was it remains to be seen how effectively these new rights will be observed. That was the slightly guarded conclusion at 231 and 233 from Lord Justice Underhill. As to the right of legal representatives to attend interviews and make submissions at the administrative stages, we do note that the MOU and the process NV 5, 7 and 8 guarantee the right to be assisted by a lawyer at every stage of the process. And the government of Rwanda confirmed the position in response to a concern having been raised by UNHCR again. They did so in an email dated the 19th of July 2022, page 3283, where they said the legal representative of the asylum seeker is permitted to attend the interview at DGIE level and any interview at the RSDC.
So at that stage, the asylum seeker would have to pay.
At that stage, it's not free of charge guarantee.
So the guarantee is simply a guarantee of attendance of a paid representative.
Or pro bono, which I'm going to
Or a
come
pro
to in a
bono
second.
representative.
Exactly, exactly. And so, turning directly to that, as to the capacity of NGOs to provide pro bono legal assistance during the administrative stages of the process, the CPIN, the Home Office note, included a detailed consideration of capacity in terms of pro bono legal advice, including taking evidence directly from the Legal Aid Forum in Rwanda, which explained, that's the Legal Aid Forum, it explained that it operated a hotline and website through which its services could be accessed, and that a number of asylum seekers had been able to receive free legal aid, and its services had been capable of being accessed. That's 4.8.7 and 4.8.5 of that CPIN at page 2434. Armstrong 1, paragraph 58, page 2675, confirms that the Rwandan Bar Association has 36 lawyers who practice in asylum law who are potentially available to provide pro bono legal advice.
And I'm so sorry, what was that page for that one?
It was page 2675. It's Armstrong 1, paragraph 58. And Armstrong 1, paragraph 60, 2 paragraphs further on, confirms that there are 1,100 senior registered lawyers in Rwanda and 300 intern advocates, and arrangements have been made to provide training in asylum law should additional capacity be required. But currently I think the number stands at Legal Aid Forum, 36 lawyers trained to provide that assistance. So the core points in relation to legal assistance are all fine at the level of appeal, for the reasons that you've seen, pro bono rather than legally aided at the earlier stages, but there is capacity, and there was extensive evidence of the adequacy of the capacity at the early stages, as I've indicated, particularly in Mr. Armstrong's statement in relation to some of those government of Rwanda responses. to similar effect, and the possibility of further training if more capacity is required to take up those numbers if that's necessary. So we respectfully submit that there isn't a proper basis for saying that there's a real risk because there will be an absence of legal assistance. That's specifically been thought about, and there are obviously checks and balances to be struck in relation to any governmental system relating to the provision of free legal advice, but there is the capacity for pro bono. There is a significant number of lawyers who can already offer that service, and that is sufficient, we submit. That's the first area I wanted to come back on in relation to the process generally. The second of them relates to the tail end piece of all of this. So supposing you have an appeal and then you say there's been a material change of circumstance at the end of that, it's the no fresh claims point. And this was something of a hare started again in the UNHCR evidence in Mr. Botnick's second statement, where they put it lightly on the basis that they were aware of no process, I think was the way they put it, whereby there was a mechanism for raising fresh claims. And the government response to that was pretty unequivocal. See page 3217, where the response is to paragraph 87, which is a reference to Mr. Botnick's second statement, paragraph 87, fresh claims made on new evidence. And the government of Rwanda say, yes, if there are new evidences and facts that were not presented before, this is done at all levels of asylum process up to the High Court. And that, we respectfully submit, is entirely consistent with the commitment in the MOU more generally to treating the relocated individual in accordance with the Refugee Convention and ensuring protection against refoulement. If there is genuinely new evidence suggesting that they are at real risk of persecution, then there's no reason to suppose on the basis of that material that the government and the processes involved will not consider that properly. So nothing in that either. I wanted, before coming to the final topic in my opening submissions, which are the past incidents that the UNHCR in particular raised concerns about in relation to the conduct of Rwanda. I wanted to have a short section at least sandwiching the process point and the past incidents of concern point, dealing with UNHCR views and how the court is to approach those views. And just to reiterate at the outset of that little section, three initial points. One, UNHCR, as I indicated earlier, does not question the good faith or genuine determination of Rwanda to deliver safe systems in accordance with the commitments it has given, as the Lord Chief noted at 467. Two, there are plainly probably unresolvable disagreements between UNHCR and the government of Rwanda about past incidents and their significance. There certainly are, for example, in relation to some of those points that I dealt with before the short adjournment, namely discrimination, to take up one example, where the actual individual incidents themselves are the subject of factual controversy between the two. Three, and it's a however point to two, as already noted, no challenge is made, in effect. There's a bit of a quibble about 8.2, I think, of the process MV, but subject to that, no quibble at all, no challenge to the content of the detailed arrangements that have now been entered into, or their ability adequately to provide safe systems. So it comes back to the judgment point, and it is clear in my respectful submission that the Secretary of State and the government are entitled and indeed bound to make their own assessment about the deliverability of the assurances, as well as the good faith and the extent of the intent and goodwill, as it were, of the Rwandan government. And that view, that judgment call, may very well differ from the views of an official or officials of the UNHCR. UNHCR's position is that it does not have judicial or quasi-judicial status in any of this. It is not, it is fair to point out, entirely impartial on the issues to which this case gives rise, given the matters identified by the Lord Chief at paragraph 465. They have in effect taken an institutional position against what they describe as offshoring arrangements, and they have, no doubt in part for that reason, adopted in this case a strong role in the proceedings, participating, again as the Lord Chief pointed out, in effect as an additional complainant. But for all of that, we do not, of course, suggest that their views on some of these issues are, of course, entitled to respect and consideration. They are the UNHCR. The degree of weight to be attached to their views all depends, we submit, on the context and on the facts, and in particular on what issues one is dealing with. We do not accept that on the current case law, as the Master of the Rolls, I think, concluded at paragraph 86, the current case law supports a conclusion that in relation to all issues, including the sorts of issues that are central to this appeal, particular weight is to be given to the UNHCR views, for reasons that I will come to. The case law is accurately set out, we submit, by Lord Justice Elias in the HF Iraq case, which is in particularly paragraphs 43 to 44 at page 5521, and the judgment, I think it was of the Court of Appeal in AS for Sugar, Afghanistan, paragraphs 17 to 23, 6572 to 6575, effectively saying it's for a domestic court to make up its own mind about these issues, and presumably, therefore, prior to that, it's for the executive to make whatever judgments need to be made about this. But as I say, this is not, as it were, any form of entire denial of the respect that should be accorded to their views on some issues. I wanted to make 4 points in particular about how that weight issue should fall to be determined and the factors that bear on the weight, the particular degree of weight that is to be accorded. The first point is that UNHCR are neither expert nor experienced in relation to these arrangements or the related more general issues, such as whether or not the various incentives that are built into the scheme can lead to a confident judgment that the state will comply with those arrangements faithfully and in good faith. And I do submit that the government is better placed to make the key relevant judgments on those issues, which is the underpinning to the submission that the Divisional Court got that entirely right. And of course, if the judgment is properly made by the government that they can be trusted to abide by those commitments in that way, then that would address the key concerns arising from the past.
Mr. James, if the acid test is expertise or experience, how does the government come out on top of the UNHCR applying that sort of yardstick in relation to Rwanda?
It comes out above UNHCR because the government and Rwanda have entered into the series of commitments that will be ex facie sufficient.
It's really because of their close involvement in the negotiations.
Close involvement in the negotiations. You've seen from the evidence of Mr. Mustard that they've had experience of dealing with Rwanda in relation, I think you described it as being development partnerships in the past, and they had come through. All of the practical incentives built into the arrangements that I mentioned earlier. And on the basis of all of those features, you are in territory which this court and other courts below you have considered on numerous occasions in the past, which are what are the levers for according particular respect for the institutional expertise within government. And it's on that basis that we say we come out on top, as it were. We're the experts in relation to this arrangement and in relation to how we can expect Rwanda to behave in future. Because, as I say, it isn't just a question of whether they're going to, in good faith, comply with the letter of those arrangements. We know the overarching aim and objective, which is to deliver convention, by which I mean Refugee Convention and ECHR compliant processes, 2.1 of the MOU. And so there is a broader question than that. See my submissions before the short adjournment and all of that. So that's the first reason. Secondly, these are new and bespoke arrangements that in fact exist. So much of what may or may not have gone before, including UNHCR views about the past operation of the Rwandan systems, is of very limited assistance. What matters is whether or not they're going faithfully to comply with these assurances, because if they do, everyone agrees that will do. Thirdly, even in relation to those past issues identified by UNHCR, it is clear that there are significant disputes with Rwanda. We're dealing here with a mishmash of historic cases or incidents. And there is a reference to will have seen in the Divisional Court's judgment at paragraph 70, which we respectfully submit that they were entitled to rely upon and correct in the analysis that followed, including the tail end of paragraph 70 of the Divisional Court's judgment, based on the fact that in their July 2020 report, UNHCR had made a statement about the fact and recorded a view that Rwanda accorded, quote, general respect for the principle of non-refoulement. July 2020, referred to in the Divisional Court's judgment at paragraph 70. But I come back to the fact that they now raise in these proceedings a series, the mishmash of cases of past concern. I mentioned earlier, submitted earlier that the Court and the Secretary of State couldn't hope to resolve those. One thing is said by one person, another thing is said by Rwanda, and so on. But you don't need to resolve that, because none of the fact of those concerns having been raised requires them to be determined, as it were. You can take into account the fact that there are concerns, that it's raised by a responsible body like that they are raised by a responsible body like UNHCR, and you can then seek to deal with them. You don't have to form a view about the extent to which they may or may not be well-founded or ill-founded or partially founded on the facts. You take into account the fact that the concern has been raised, and you seek, precisely as was done in this case as is confirmed in the evidence, to tailor your commitments and to design your new scheme and the things that they are committing to with those in mind. And remember, Othman, even if there were accepted concerns of the most serious sort of, quote, routine ill treatment, nevertheless, that did not undermine the specific assurances that were given that he, Mr. Othman, Mr. Abu Qatada, would be treated properly if he were to be returned to Jordan. It is possible and permissible under that case law for assurances to provide that break, but they certainly provide the critical and core focus of the assurances of future conduct, which is what we are concerned with. So even if one takes as well-founded pretty much all of the UNHCR concerns, the fact remains, or the answer remains, not under the arrangements now in place. The fourth point is that there has been, unsurprisingly, the most serious and extensive consideration given to those issues raised by that body by the UK. We were aware of them when designing and setting the content of the assurances given. Some new ones that were raised later on in the piece during the course of the litigation were then properly put to Rwanda, and the Rwandan government produced its responses to those. And there is nothing wrong, we submit, in terms of either process or final outcome with adopting the course that I described in my earlier points. which is that the concerns are taken into account in making absolutely sure that when the commitments are written down, everyone understands what is expected to be delivered. And we submit that the core and overarching answer to all of the concerns raised by the UNHCR was indeed the one given by the Lord Chief Justice at paragraph 509 in his judgment. Can I just invite you to take that up? Sorry, just to give you the core answer to it. It follows quite a lot of reasoning that's gone before, but it's a helpful summary of this issue. It's in the key documents bundle, sorry, 358. I could probably give you the court hearing bundle if someone will give me that. Court hearing bundle for the Court of Appeal, Lord Chief, 509.
Starts at 465.
Of the core. What Lord Chief?
Key documents, did you say what page?
I said 358 of the key, sorry, I'm being slow. 619 of the core of the hearing bundle. But it's page 5, paragraph 509 in the Lord Chief Justice's judgment.
Yeah.
Can I then turn to the past incidents of concern that were raised?
Before you do so,
Yes.
can I raise a matter with you that's been bubbling away? I don't expect you to deal with it here and now, and I don't expect Mr. Hussain to deal with it today either, but it might be helpful if you could address me on it at some point. What's going through my head is this. We've been approaching the case on the footing that it's necessary to demonstrate some flaw in the divisional court's approach. Either they asked themselves the wrong question, or they failed to have regard to material evidence, or something of that. In other words, a sort of Henderson and Foxworth approach. Before this court, or indeed the Court of Appeal, would be entitled to look at the matter for itself. And all that's going through my mind is just to wonder if that is necessarily the right approach to take to this. What's going through my mind is that because this is an ECHR case, although it may be the same would apply anyway, applying Baghdasi and the idea of anxious scrutiny. But it is an ECHR case. We know that from Ilias that the contracting state, of which this court is an organ just as much as the Secretary of State is an organ,
Yes.
has a duty to carry out a rigorous consideration of whether there is a real risk of refoulement. So what's going through my mind is to wonder whether we, in principle, should be quite as hands-off the fact-finding exercise by the divisional court as
Or the Court of Appeal.
or the Court of Appeal, as the submissions are really on both sides.
Yes.
Are really assuming.
My Lord, I'll think about that. I mean, it's the first part of the answer to that is to recognise that if and when, or if, this case ever gets to Strasbourg, the Strasbourg court, it is clear on authority, will approach the issue of real risk at the date on which it considers the case. But there's no doubt about that. That was made clear in Vilvaraja and all those cases that followed Bugdeka from Sri Lanka in the early days. So they would undoubtedly do that. But I confess that my understanding has always been that this court, under our constitutional arrangements domestically, is in a rather different position. And it's in a rather different position because the evidence before the divisional court effectively froze at July, or early July of last year.
Yeah.
And then the position, again, as I've always understood it, has been that the appellate courts act within the strictures of their own domestic constitutional arrangements governing the functions of the first instance court as compared to an appellate court. So although there is some fluidity in the domestic legal tests as to when you can intervene with the court below, and wrong can encompass a multitude of sins, no doubt, ultimately, you are nevertheless appropriately to deal with this case on the basis that you and the Court of Appeal are approaching it as an appellate court. And that would, of course, mean, and may, of course, mean that there may need to be, will no doubt be, if assume for the sake of argument that the green light is given here, just for the sake of argument, there will no doubt need to be round two, at which no doubt it will be said there have been new developments in July 2022, and that will have to go wend its weary way through the court processes, at which point we'll all be up to date by the time we hit Strasbourg, or we won't.
Yes.
But so my answer to my Lord's question is that, I mean, I will think about it some more, but my understanding is that the conventional rules that govern how appellate courts are to approach the issue does not disappear and get replaced with a more first instancy type approach, simply because this is a Vilvaraja or Bugdeka type or ECHR Article 3 type issue.
You may very well be right, and I'm not suggesting that the temporal focus shifts. I mean, the evidence is obviously at the date the evidence was
Frozen at the date.
and that must be frozen.
Yes. Your question is more about whether it should be a bit more hands-on as an approach
Yes,
at the appellate level.
What we did look at this question in relation to assessments of proportionality quite recently in the case about abortion
In Northern Ireland.
safe zones, the Northern Irish case.
Yeah.
There's a discussion of the role of appellate courts
On that issue.
on that issue,
Yes.
suggesting that, if you like, it depends on the nature of the case. That if we, for example, if it's a proportionality of a particular child being taken into care, then that's a matter you leave to the family judge, and an appellate court would only interfere if something had demonstrably gone wrong.
Yeah.
But if you're talking about a case like Bank Mellet or SC on the two-child rule, or
Yes, yes.
et cetera, Nicholson would be a classic
Yes, yes.
example, then the appellate court, where there's a major normative issue, will be much more hands-on in looking at proportionality. Now,
May I have a look at that case overnight? I'm very well aware that there has been a debate that's been rumbling on for some time about how you approach proportionality as an idea at the appellate level. May I look at that overnight? And
yes, certainly. That's what I was suggesting. You might want to look at it and perhaps come back to it in your reply. And it may be that Mr. Hussain might want to come to it at some point tomorrow.
Well,
Could I just add on that? I mean, proportionality, as was made clear in the safe abortion zones case, is itself a question of law. So there is obviously a balance to be struck between to what extent a court gets involved in
as an issue of law.
level, in dealing with an issue of law, and to what extent matters are thought to go off purely on the facts. So it's not enough to say, well, proportionality is a special case. It's an example of an issue of law where the outcome to that issue may depend to a lesser or greater extent on factual matters.
Oh, yes. May I think about it with that assistance in mind, as it were?
Yes.
I'm rather comforted in the fact that I've been giving you very dull references into the evidence.
No, not at all. It's extremely helpful, and we're very grateful. And I'm not suggesting that this is a hair that I'd like to follow a little bit just to see if it leads anywhere. It may be it doesn't.
No. Well, my Lord, I'm sure, certainly from our side, we're not you will have detected, we are not discouraging this court from getting stuck into the facts to some degree at least, not least because of the clear conclusion reached by the majority, in particular Lord Justice Underhill. And obviously it would be a bit undesirable if one were to ever end up in Strasbourg, on the basis of, well, we're not sure, we're not going to go there, as it were. But I'll think about that issue of principle, if I may, a bit more.
Thank you.
Concerns about past incidents, I was going to deal with as my last substantive topic. Almost all of these concerns relate to instances identified principally by UNHCR, but instances in which a person or persons in a variety of slightly different contexts may have been removed in the past from Rwanda without, as it were, determination of their RC, their Refugee Convention rights, and or inconsistently, it may be suggested, with international arrangements made with another state. The first thing to note in relation to those concerns generally is that there have been a series of commitments undertaken by Rwanda which are directly relevant to the risk under these arrangements of a person simply being removed to another country, still less turned away at the airport in Rwanda. Just to trace through them, the MOU itself contains a series of relevant provisions on that front. 2.1 we've looked at already, containing the overarching objective for all of these agreements, which is to create a mechanism for the relocation of asylum seekers, their claims to be determined in Rwanda, and as 2.1 puts it, which will then process their claims and settle or remove in accordance with domestic Rwandan law, Refugee Convention, current international standards, and so on. So there's a specific provision, that's the aim and objective. C also for doing things in accordance with the Refugee Convention and other international standards. 4.1 of the MOU on page 2368, 7.1 and 9.11, all of which are to the same effect, all effectively reinforcing the intent and commitment to deal with people in accordance with the Refugee Convention and other international standards. And you get the same idea, the same point in the reception and accommodation note verbal. So far we've been focused on the process for obvious reasons, but there's a separate note verbal which deals with the treatment that they can expect when they are in Rwanda, health, food, accommodation, and all of that. That starts substantively at page 2386. And for this purpose, i.e. setting up an entire process to enable things to be dealt with compatibly with these conventions, see paragraph 15.1, dealing specifically with compliance with the Refugee Convention on the ground in Rwanda and in relation to those matters there identified. Going back to the MOU, we looked earlier at the idea that all, and it's particularly important to the idea that there is any risk at all of people being turned away at the airport. We looked at the before paragraph 3.2 of the MOU on page 2367, and the whole system of prior approval by Rwanda before anyone gets relocated. So they're going to approve transfer requests on a case-by-case basis, and that is the way it's going to work is clear from 3.2 and also clear from the consequential provision in 7.2 of the MOU at the bottom of 2368. So they're going to check them against the list of people who've been approved as soon as they arrive, sort of thing. It's all part of the beginning of this intensive audit process that Rwanda gets to approve before anyone comes. And from there you go to the process NV. Again, we probably looked at this earlier, but just to repeat it in this context, the process NV at 3.1, under which everyone is clear that the whole idea of this is that a relocated individual will, to quote from 3.1 on page 2379, have the opportunity to make an asylum claim, and so on. So they're going to process the claim, they're going to accept the individual, they're then going to be put into the system for the very purpose of determining the claim, with all of the financial incentives that are attached to that. And the overarching undertaking and commitment is to do so in accordance with the Refugee Convention. And 10 of the process note verbal forgive me, I've got a Duff reference.
383.
383.
Yeah. Sorry, will you just give me 1 second? Yes, I'm so sorry. It was 10 of the MOU. I was muddling up the two. So thank you for the page number, but it was the initial reference that was wrong. Paragraph 10 of the MOU, 2369. So here there are a whole load of provisions, a bunch of provisions within paragraph 10 of the MOU, which deals with how people are going to be treated at the end of the process. And it deals with their right to apply for permission to remain, how long for, and all of that. So if you just cast an eye down, I just want you to get the basic nature of paragraph 10. So there's specific provision, not merely for how these claims get determined, but for what happens at the end of it, which is to some extent dependent upon outcome. And to some extent this goes to the point about what's the reality of the risk that they're actually going to be returned to Syria or wherever it may be. But the broader point in relation to these is that there is specific provision being made not merely for the process itself, but for the, depending upon the outcome of the claim, what rights and responsibilities Rwanda will exercise in relation to this cohort, including the ability to or the responsibility to offer an opportunity to apply for permission to remain in accordance with its domestic laws, even if they are unsuccessful in their refugee claim, and even if they're unsuccessful in their humanitarian protections claim. So you see the points in paragraph 10. Then under that head and on the same theme, you will see the point about other humanitarian protection built into the process NV at paragraph 4.10 on page 2381, and you will see the if refused refugee status or other humanitarian protection offer the opportunity to regularize their immigration status, you will see that point from paragraph 10 of the MOU then reflected in what I've called the reception and accommodation NV at paragraph 16.2, which refers back to 10.3.1 of the MOU on page 2391. And on the no returns, is there an agreement with any of the countries from which these claimants come? And general responses to removals. Can I give you some references into the evidence, if I may? Firstly, the government of Rwanda response to UNHCR at page 3204 and 3206. See in particular, if you would, paragraphs 5, 10, 11 and 13, explanations about non-refoulement and individuals being offered legal residence in Rwanda. See Mr. Armstrong's first witness statement, paragraphs 84 to 85, page 2682, dealing with no returns. And see the government of Rwanda table of responses at 3242, paragraph 12, summarised as no forcible removals, 14 and 22, no present intention to enter into removal agreements with the countries from which these people come, 21, dealing with airport refusals, and see also in the evidence the final reference, Mr. Williams' statement at 46 to 48, page 2706. The core points at this stage, therefore, are that the commitment is not just a reaffirmation of compliance with the Refugee Convention, which Rwanda is obliged to do anyway because it's a signatory to it. It's a reinforcement of that, but it's not just that. The entire framework of these arrangements sets out processes to be followed in determining the claims of those removed and then dealing with them even thereafter in accordance with the clear and detailed commitments in the MOU governing removal. And the very purpose of the reception of these individuals, with all the financial incentives attached, is to process and treat them accordingly. There's really no realistic risk at all that they will be simply removed without that process having been gone through at all. That would be a flagrant breach of the agreement, and it would be a bad faith point, and no one suggests that. To turn to the specifics of the concerns raised by UNHCR, there was some focus below at both levels on a UNHCR table of instances of what they say were refoulement cases, recording some 90 instances of possible refoulement. And that you find, if you need it, in the bundle, the hearing bundle at 2101. And the key ones for present purposes are the cases in which significant numbers of individuals, it is said, were returned or removed to another African country, and they had come to Rwanda under the Israel-Rwanda agreement. That's the bulk, I think, of the cases. And then a smaller number of cases involving what is described as airport refoulement, so in other words, removal before any determination of the claim from the airport. There were 2 Libyans in February 2021, a Yemeni in September of that year, 2 Afghan nationals in March 22, and a Syrian national, I think, in April 2022. There was an additional category in relation to removal to another or denial of access to asylum procedures in relation to individuals from a non-African country with which Rwanda has close diplomatic relations. But I hear what anyone says. I suspect that one has rather dropped away. So I'm going to focus on the first 2 categories. Israel-Rwanda, the arrangement, that is dealt with in particular in the Court of Appeal at paragraphs 90 to 91, in the majority judgments, 101 to 102, and 152 to 156, and it's dealt with by the Divisional Court at paragraphs 67 and 68. And the core points we make about that arrangement are these. This was, as far as one can tell, a different arrangement with a different state to which the United Kingdom was not privy. And it was in place, it appears, between 2013 and 2018, so some years ago. So it's a different set of arrangements. The United Kingdom, for all the reasons I've made clear already, is entitled, we submit, to make its own judgments about the future conduct of Rwanda, a friendly foreign state with which it has a long-standing relationship. And that's all the more so in the circumstances that I have outlined, where formal, detailed arrangements precisely designed to ensure proper processing and proper removals, if there are to be removals at the end of that process, all of that is in place. Everyone involved is crystal clear about the reputational impacts that are involved if this goes wrong. The arrangements have been in the public domain from the outset, and Rwanda has ongoing financial interests and incentives in making this work. And as far as one can tell in relation to the Israel arrangement, that involved, see page 2878, or appears to have been to have involved, as the Divisional Court noted at paragraph 67, Israel in effect paying for the trips of those who were removed and giving them a one-time payment of $3,500 US without assisting beyond that point. So you don't have...
Again, Sir James, I'm sorry. The reference again, please, I'm sorry.
2878, my lord, sorry. 2878.
Thank you very much.
But it looks like it was a one-off payment to the migrant rather than the kind of built-in structural, we're going to assist and you get a payment per person and all of that.
Is the UK government's position that they were under no obligation to look into the Israel-Rwanda arrangement because it was irrelevant?
My lord, pretty much it is, yes.
Yes.
We respectfully...
Why is that? I mean, because it is an example of Rwanda cooperating with another country on third country processing of asylum claims.
Well, my lord, because we submit that the United Kingdom government is entitled to look to its own house and to make its own considered judgments that Rwanda will comply with the serious assurances that have been given in relation to the arrangements we have entered into. Those assurances, was the government's view, if complied with, will entirely remove the risk of anything similar occurring to the concern raised about the Israeli removals. And in those circumstances, there is no need to chase down the details, even if it were possible, in relation to another international agreement where the relationship between the two countries may be different in general terms, and where the specifics of the arrangements are, whatever else may be said, on any indication, highly unlikely to be anything like the same. And in any event, perhaps it comes more directly to my lord's point, although those are the principal answers, in any event, it's likely to be very difficult to do so. It may well be sensitive. There may well be areas which neither government is prepared to discuss. Likely to be very difficult indeed to reach a clear or firm view about comparability or whether or not that provides any useful indication at all. If it's said, as I say, if it's said that the relevance of that is because it might tell you that Rwanda traditionally breaches its international agreements, then that's a bad faith point. And no one's challenged this on the basis that Rwanda is going to act in anything other than good faith. So for all of those reasons, particularly the difficulty or potential difficulties of doing so, but as significantly in principle, we respectfully submit that there was no need to chase down any details of this. Indeed, on the difficulties, the very identity of the countries and the details of the arrangements appear to have been, if the late produced in the Court of Appeal Israeli Supreme Court judgment governing this or dealing with this set of issues, anything to go by, paragraph 3, page 2950, the detail of the arrangements was withheld even from the domestic Israeli courts pursuant to a certificate of privilege.
They don't mention
Don't mention Rwanda. The president in the Israeli court commented that she was not comfortable, as she put it, see paragraph 82, page 2994, not comfortable with the relocation to a third country on the basis of a secret agreement whose provisions are not known to the deportees.
Yes, but this might suggest that if the UK government had tried to investigate the matter, they wouldn't get very far. The UK government's decision is an earlier one that they didn't have to investigate the matter.
My lord, that is true, and that's for the reasons of principle that I gave you. The view was taken that the proper focus was on our relationship with Rwanda, was on our arrangements with Rwanda, and as I say, the only conceivable relevance of this would be to suggest that because or if a series of individuals were removed following the Israel-Rwanda agreement, then that might provide some succor to the argument that Rwanda would deliberately breach the arrangements with us.
I see the point that it's a given that the agreement will be operated in good faith, and the focus is on capacity and capability rather than dishonouring agreements.
That's really the essence of it, coupled with the likely difficulties, although of course I accept, my lord, that may be you might not get much rather than you don't have to do anything. But there's a pretty strong likelihood that we wouldn't have got much, as it turns out. So that's what we say about that. I think it is, and I emphasise, it is an important point that if it's going to be relevant at all, it has to be relevant here to say, a case has to be made that it's relevant here to say, well, there's the Israel-Rwanda agreement. Why doesn't that tell you that you can't trust Rwanda to abide by the assurances it's made? And that's not the case that's made by anyone. There's no good faith argument at all. So the fundamental question ultimately reverts, even if you assume that all of those individuals were removed by Rwanda and came under the Israel-Rwanda agreement, where there were, as it were, general guarantees that they'd be treated in accordance with the Refugee Convention. Even if one assumes that they were then removed in breach of at least that generalised assurance, there's no real risk of that happening in our case, given the detailed nature of the arrangements made, given the absence of a bad faith allegation, and given that ultimately compliance with those arrangements that we have entered into as a matter of judgment, paradigmatically for the United Kingdom government to make, we submit. So the Master of the Rolls concluded ultimately that the Israeli judgment does show, that's the judgment of the Supreme Court that was produced at the level of the Court of Appeal by UNHCR, I think it was, does show, paragraph 87 concluded the Master of the Rolls at paragraph 102 of his judgment, that the agreement included, as he put it, an explicit undertaking of Rwanda, according to which deportees would enjoy human rights and freedoms and the principle of non-refoulement shall be complied with, and that, in his words, constituted some evidence that the breaches mentioned by the UNHCR occurred, notwithstanding the Rwandan government assurances to the contrary. Well, that may or may not be right up to that point. Our point in answer is you need to go to the next stage of the analysis and of that logic. And our answer is, not merely do we still not know all the details of those cases or the details of the assurances, but we don't need to go there, because even assuming that that is so, the question remains, and it's a question of judgment, whether under our arrangements there is any real risk of that occurring. And we respectfully submit that for all the reasons I've given, there is no real risk of that. So, my lord, that's what I wanted to say about Israel-Rwanda. Then the Kigali Airport's refoulement cases, the 6 instances that I've mentioned, I can take that a little more shortly. The key and short answer to those cases, that's cases where people arrive, and I think they're cases where they say, well, you didn't have the right documents or you're exercising deception on your entry provisions, all of that. But the key and short answer is that there is plainly no real risk at all of the same thing happening with any of the relocated individuals. Indeed, the UNHCR accepted that at paragraph 28 of their observations before the Divisional Court, C2089, for that acceptance, paragraph 28. The 2 key points are these. One, the very purpose of the MOU is to transfer individuals for Rwanda for processing and determination of their asylum claims, with approval processes to approve each and every transfer request prior to relocation, 3.2 of the MOU which you saw, and with a financial incentive for Rwanda to accept individuals as they receive a payment to support the costs of processing each asylum claim. See Armstrong 1, paragraph 16, Roman 3 to Roman 6 at page 2656 and following. 2656 and following. The second point is an if necessary point, and we submit it isn't, but it's that even if Rwanda were to refuse to accept an individual having previously done so at the airport in some way, that asylum seeker would be returned to the United Kingdom, as that is where they travelled from. Rwanda doesn't have a return agreement with any of the countries of which the individual claimants are nationals. See Armstrong 1, paragraph 85, page 2682.
Finish Nulla.
I've done the number.
I've just got to ask, in relation to someone who has, let us say, an Eritrean passport, does Rwanda need a return agreement to put him on an air flight back to Eritrea? After all, when the person arrives in Eritrea, he produces the Eritrean passport and one assumes is let in without any further ado.
My Lord, that may or may not technically be right.
Well, I'm not asking it as a matter of technicality, but a matter of substance.
Well, let's assume it's right. They have confirmed they do not enforce removals to any Middle Eastern countries. That's page 3470. And there's no evidence that they've ever sent anyone back there. But they confirmed that in their, that's from the individual 5th of July inadmissibility decision 3470.
The refoulement to Syria that UNHCR referred to was indirect.
Was indirect, exactly.
Via Turkey, I think.
It was, I think. It was. Which is why the second point is much less important than the first. But it is nevertheless right to record it without getting too sucked in. I'm very well aware that in their case, my learned friends have said, well, you may not need an agreement, and fine, I'm prepared to accept that for the purpose of this argument. I don't really care. The key point is no one gets to Rwanda under this set of arrangements unless Rwanda has said we will receive them with all of the incentives then and the agreement that they will do the processing and do the determination.
I was just looking at paragraph 10.4 of the MOU, which I think is 2370. And tell me if I misunderstood this, but it seems that if they neither get recognised as refugees nor have any other basis to stay, and we've seen the levels at which that's pursued if they lose on their asylum claim,
Yeah.
shown us that. Rwanda will only remove such a person to a country in which they have a right to reside. That appears to leave wide open the prospect that if they get the asylum issue wrong, then there is a risk that the person will be removed to his country of origin, because that may well be the only place where that person does have a right to reside.
But by then they'll have gone through the process. Of course,
accepting
it puts,
all that, accepting
it
they
puts
can't
the
get a
force
work
on.
permit and they've got no other humanitarian reason for staying. But this will be a person who Rwanda has concluded is not an asylum seeker.
Yes, it will. My Lord, you're right, but query what lies behind that. One of the things, of course, is that they have to have a right to reside there, so that's an additional condition. Query by virtue of what international arrangements, if any, removals to particular countries might occur. So I'm not saying it's impossible. We're not saying the issue of process doesn't have any potential consequence, but there is that second limb of reality. How likely is it? Is there a real risk that they will then bounce on, as it were, if the process doesn't operate properly? And this, of course, introduces the additional precondition that says they've got to have a right to reside there. That opens up that possibility, but it may well be that there are additional preconditions, namely a set of arrangements which will enable Rwanda to do that. But I'm not saying there's no potential significance to the process issues, if that helps. I'm reminded, Lord Chief Justice, paragraph 470, none of the applicants here has a passport. Thank you.
But I presume you're wanting us to look at the policy on a broader basis than merely the particular claimants we have.
Yes. So it's a to-note point rather than a complete answer to the point that all raised.
I mean, and also, if they have a passport, they might have a right to reside.
They might. So, my lords, for those reasons, we do respectfully submit that all of these issues are, in sum, dealt with in the detailed arrangements that have been made. Fundamentally, that raises the question of judgment: are they likely to comply, and not merely to comply in good faith with the letter, but to seek to achieve the objectives specifically identified in 2.1 of the MOU. And for that reason, we submit there is not, as the Lord Chief concluded and as the Divisional Court concluded, or there are not substantial grounds for believing a real risk exists in these cases in relation to refoulement. As I say, I'll come back to the conditions on the ground in Rwanda in answer to the permission to appeal that the claimants have got on that separate issue, and I'll also come back on Ilias and procedural matters, although it is perhaps worth flagging just very briefly at this stage. The case that's been mounted to date, at least in relation to Ilias, seeks to present us with a Morton's fork. It's either very bad against you, or if it isn't, you should have done more investigation to work out that it was very good. And we respectfully submit that that isn't the right approach. What Ilias does is to impose a duty of thorough examination, as it's put, of the systems in the foreign country, but it does so in the context of cases in which really no examination of any kind has been undertaken by either the executive or the courts in the state concerned, and that is often because they've assumed that it's in inverted commas, a civilized country, and so why would we need to? And sometimes that isn't the case, but we do respectfully submit that there needs to be and is under the Strasbourg case law, some form of procedural obligation, but it is not the chase down every issue to the nth obligation that my learned friends seek to suggest as part of their creation of the Morton's fork. My lords, unless I can assist further, those are my submissions in opening.
Thank you very much, Sir James. Mr. Hussain.
My Lord, you received a letter from me. Could I have 1 minute?
Yes, certainly. We'll adjourn and resume in 5 or 10 minutes. Yes, Mr. Hussain.
My Lords, I'm very grateful. My Lords, to avoid duplication, my learned friends, Ms. Kaufman, Ms. Knight, and Mr. Drubble, have very kindly agreed that I will have carriage of the Article 3 arguments, though, of course, if any issues arise on their specific cases, they will seek to assist the court. The downside, of course, is that you're stuck with me. My Lords, the Secretary of State's Rwanda policy has to tread a difficult line. The justification for the policy, as your Lordships have heard, is that it is hoped that removing asylum seekers to a third country will deter dangerous crossings and the criminal gangs who prey on the vulnerable. But there will only be any form of deterrent effect if a third country to which those asylum seekers are removed is one to which they would not wish to go. In other words, the third country has to be sufficiently unattractive that its use may deter entrance into the UK, but not so unattractive that it places the UK in breach of legal standards. Secretary of State's case accepts that at paragraph 7. We respectfully submit that the Secretary of State has failed to tread that difficult line, and indeed has done so by a considerable margin. Whatever its other attractions, we respectfully submit that Rwanda is an authoritarian, one-party state which doesn't tolerate criticism. It is a regime which repeatedly imprisons, tortures and murders those it considers to be its opponents, including after they've fled the country. Indeed, it tried to assassinate dissidents in this very country during the pendency of an MOU in support of an extradition request. Freedom of speech is absent. Those who protest or dissent from government directives, including refugees, are faced with police violence and legal repression. The Secretary of State knows all of this. Her officials have repeatedly recorded their concerns about it, as indeed the courts have. More pertinently, for present purposes, the Rwandan asylum system is woefully deficient. It is marked by acute unfairness and arbitrariness, some of which is structurally inbuilt, and by serious safeguarding and capacity issues, that is to say, in terms of skills, experience, ability, not simply numbers, some of which can be remedied only by structural changes and long-term capacity building. That is UNHCR's institutional view, recorded by the Master Rolls at paragraph 7. The Secretary of State, we say, has an uphill task in seeking to defend the Article 3 compliance of the Rwandan asylum system and Rwandan asylum practice in the face of searching, evidenced, meticulous criticism by the UNHCR, the overwhelming majority of which was rightly accepted, not just by the majority, but also by the Lord Chief Justice dissenting. I'll just give you 3 references in his dissent: 493, 500, and 502. In order to defend the Rwandan asylum system, the Secretary of State, moreover, advances submissions that have no support in principle, in precedent, or in the evidence. Thus, Sir James claims that the Secretary of State's view of the assurances not only on the issue of good faith, but also as to the ability of Rwanda to deliver on them, commands respect on grounds both of institutional expertise and democratic accountability, and says that this is a matter for political rather than judicial judgment. That is the Secretary of State's case at paragraph 81. It's a heretical submission with respect. Secondly, she does not dispute the state of the Rwandan asylum system significantly, as found by all of the Court of Appeal, including the Lord Chief Justice, but rather seeks to ignore it. She considers the past, indeed the present, to be at best of peripheral relevance, and the evidence of large-scale abuse and refoulement under a similar arrangement with Israel that ended only a few years earlier to be of none. and that is despite not having investigated it. And this is on the basis that the assurances change everything. That's her case at 16. Thirdly, she accepts that UNHCR have expertise in the working of the Rwandan asylum system, but says they have none as regards how the assurances might work, despite the fact that the assurances are designed to ensure compliance with the Refugee Convention, something on which the UNHCR might have some expertise, just perhaps, and despite the fact that the so-called bespoke MEDP system is not a new parallel system, but an adapted one that was launched, presumably on the 14th of April, by Lord Lloyd Jones. Fourthly, and that's Secretary of State's case 88.2. Fourthly, the Secretary seeks to reverse the application of precautionary preventative principles that apply in the anxious Article 3 context so that they operate in her favour on the basis that the Raymond approach to assessing national security is apposite here, or the approach articulated by Lord Bingham on the question of public emergency in aid, when in fact the reverse is true. That's her case at paragraph 79. Fifthly, she misreads the Divisional Court's judgment in Nisrayu, ignores the general conclusions reached about the almost total capture of the Rwandan judiciary, paragraph which Sir James, very unlike him, is usually very accommodating, did not take you to at my invitation, was paragraph 149, where the findings are set out in fully emphatic terms, and it is said that the judges have loyalty to the party rather than to justice. So she misreads that, and essentially she advances the Rwandan judiciary as a necessary safeguard for the system, and essentially relies upon the Lord Chief Justice at 116. And the case is essentially she's inviting this court to accept the proposition that the Rwandan judiciary will deliver independent justice because the Rwandan executive will tell it to. That's a startling proposition that is advanced in this court, the Supreme Court of the United Kingdom. Sixthly, she says that monitoring of a wholesale system change will deliver safety in individual cases, even if the asylum system won't. And that's her case, paragraphs 90 to 100. Seventhly, she claims, faintly now I think, that we don't have to worry about the safety of the Rwandan asylum system anyway, because by way of dimly evidenced policy that is totally contrary to Rwandan law, individuals won't in any event be removed. I think you had a bare reference from Sir James to that submission. It wasn't developed except in a different context. I will seek to show you that it has no basis whatsoever in Rwandan law. My lords, these are extravagant claims that should be rejected, even if this court was sitting as a trial court. I'll come back to the exchange between Lord Sales and Lord Reed in due course. At the very least, they do not show either that the Divisional Court was right or that the Court of Appeal majority were wrong. I'll make our submissions on the detail on the answers of law and fact on these core issues when I address grounds 2 and 3, if I may, of the Secretary of State's appeal, as we have done in our written case. That is, in our respectful submission, where the significance of the appeal lies, both in relation to the legality of the Secretary's policy and the reasons why my clients and those of my own friends are concerned about being removed to Rwanda. Those issues form the substance of the appeal, and in our respectful submission, without a detailed understanding of the evidence and the law in relation to them, it's impossible fairly to address which of the courts below were wrong. We say, of course, that the detailed and analytical consideration of the issues and evidence by the Court of Appeal majority, and with great respect, the stark contrast that provides with the failure of the Divisional Court to address much of that evidence at all, and still less of it with necessary rigour, provides a clear answer to that question. But I'll deal firstly, much more briefly, if I may, with the two aspects of ground 1 and the specifics of the reasoning of the Divisional Court, which we say entitled the Court of Appeal to reconsider the factual issues. There at least appears to be little dispute between Sir James and I as to the applicable principles, save insofar as he seems to suggest that mere disagreement suffices to establish a decision is wrong, his reliance on the Chief Justice, and he seems to regard the issue of the Divisional Court's judgment, he seems to regard the idea that, seems to advance the idea that we have to say that the Divisional Court's judgment wasn't open to it to be wrong. That's obviously not the case. But essentially, if you look at our written cases, there's nothing between us. And as I said, I'll come back to the very interesting issue that my Lords raised. I know this is something that Lord Sales has written about, and I think it was a Z case that pricked your conscience, my Lord, this issue, appellate function and rule of law concerns. We'll come back to that. But our position is that we meet the Foxworth test, the orthodox Manchester test, for reasons I will develop in due course. May I then please turn to the first gateway question, ground 1. This is SFI 23.1. This is the misdirection question. This is the first of the gateway issues. It concerns form. Did the Divisional Court misdirect itself? The second gateway issue, was it wrong, obviously concerns matters of substance. Because it concerns an issue of form, I'll take it relatively quickly, if I may. You've seen the judgments below, and you've got the points in our written case. So 6 points, if I may. 1, we respectfully submit that our reading of the Divisional Court judgment accepted by the majority does not depend upon a strained and narrow textual analysis, nor does it depend upon poring over the judgment as if it were a statute or a contract. We don't commit either of the sins Lord Hoffman, Piglovska, Lord Justice Lewis in Volpe. We say that Sir James is guilty of those errors because an objective reading of the judgment as a whole clearly shows that the Divisional Court failed, for whatever reason, to ask the Article 3 question for itself. Mr. James has to adopt a strained reading and subject the judgment to over-fine analysis to overcome and finesse the Divisional Court's persistent use of language that it was in tension with, if not inconsistent with, its agreed task. That's the first point. Second point, the issue isn't what the court intended or whether it would have understood what it understood the test to be. No doubt it understood the test. The Court of Appeal majority recognised that. See our case at paragraphs 28 to 29. The majority's starting position was that the Divisional Court understood the law. It applied the Piglovska presumption that unless the judge has demonstrated to the contrary, he knew how he should perform his functions. So that's Lord Justice Underhill at 129, that's the reference, he doesn't accept for a moment that this experienced court failed to appreciate the difference in approaches. But he said that we've got to proceed by the language which it has used unless it's clear that that doesn't reflect its true reasoning. And that made a lot of sense, because one could have a situation where you have a court that directs itself impeccably, concludes impeccably, but goes awry in its reasoning. You could there have a situation where the language doesn't reflect the court's true reasoning. That's not the situation here. With great respect to the court, for whatever reason, the fact that it was also dealing with public law grounds, I accept, but that's the point in our favour. As Lord Justice Underhill said, that suggests that it became confused to the test it needed to apply. The Moss Rolls at 73 also said it would be remarkable if such an experienced divisional court had, in fact, addressed the wrong question. They came to the conclusion that it did with reluctance, as we see.
Just on Lord Justice Underhill at paragraph 129,
Yes.
I mean, he says there he doesn't regard the issue as of critical importance, that is, the self-direction issue. So he does seem to proceed on the basis that even if the self-direction were correct, the appellate court, in this case, had a more extensive role in determining whether the answer given was wrong or right than simply looking to see whether the self-direction was right.
No, I think he applied orthodox principles on wrong, the Manchester approach, essentially. He says at 270 that the reasoning can't be supported. That's my ground 1B. I'm going to come on to that and show you why he clearly found that. In fact, so did the Master Rolls. It's very clear in the consideration of his issue 3. He also found it was wrong. And I'm going to say it doesn't matter whether he did or not, because your lordship should find that the divisional court was wrong. But that's the issue of substance on ground 1B, as we call it. It's SFI issue 23.2.
But just on that, I mean, if the proper approach for us is to ask more generally whether the answer is wrong, without letting the answer to that question depend upon a misdirection by the court itself, doesn't that reasoning also apply to what the Court of Appeal has done?
Yes,
I mean, we're in an unusual situation. The Secretary of State's trying to say, oh, hands off the divisional court because they self-directed correctly.
Yes.
And you're at one level saying hands off the Court of Appeal because they got it right.
The gateway questions we can subdivide into two grounds. Ground 1A, misdirection. Ground 1B, wrong. CPR 52Z, Hackney.
Okay.
Your lordship held, I think it was paragraph 74, that approach also applies to appeals to this court. The doctrine of wrong should be a legal doctrine.
I just wanted to check where we were.
Yes. So that's ground 1A and 1B. Grounds 2 and 3, I completely accept, bleed into 1B, because there is commonality across some of the issues, not all of them, as regards was the divisional court wrong, was the Court of Appeal wrong. But our position is that we meet the Foxworth test as regards the divisional court, or the Greater Manchester test as regards the divisional court, to the extent there's any difference between them. There may be a nuanced difference. We meet that with regard to the divisional court. That's ground 1B. Issue 23.2, something on which I think the Secretary of State has one sentence in her entire case. We meet that. The Secretary of State doesn't meet that threshold to sustain an appeal to this court. Indeed, if I may say so with respect, many of Sir James's submissions were as if one could completely ignore the majority and disagreement would be enough for your lordships to intervene. But our position is the gateway question, ground 1, bifurcated, misdirection, wrong, CPR 52, and then there's an issue of the sustainability of the Court of Appeal's reconsideration, grounds 2 and 3, where it's not a free-for-all. The Secretary has to show that the Court of Appeal was wrong. Majority was wrong. And I'm going to say she can't simply point to the Lord Chief because he doesn't articulate why the majority are wrong. He doesn't attempt to. It's a disagreement. That's the shape of my submission. We're going to reflect upon the points my Lord's put on the abortion issue and rule of law. But I'm still on ground 1A, and I was about to make my third point. And my third point is that it is plain that the divisional court used the language that is the unambiguous language of judicial review, as Lord Justice Underhill said at paragraph 129. It used entitled 5 times, paragraph 39.2, paragraph 62 twice, 39.2, yes. 62 twice, 64 and 70. And that language, we say, reading it in the round generally, suggests, rather than on a strained basis where one's finessing the term, suggests that it's considered the Secretary of State was the decision maker, not the court. I'll come back to Sir James's answer to that. It considered whether there was a legal flaw in the decision at 71. It considered whether the decision was lawful at 45. Thank you. At 45 and 71. And it asked the question whether the Secretary of State's approach was permissible or disclosed an error of law. Paragraph 68. Now, we say you have to bend language to breaking point to say that that is consistent with the court asking the Article 3 question for itself, particularly because when it asked that question on the in-country issue, 74 to 77, it did not use this language. The fourth point I want to make, if I may, my lords, is that it expressly, and this is something that's very important because it's conspicuously absent from the Lord Chief Justice's judgment on this point. It's absent from Sir James's written case, and it's absent in his oral submissions. Paragraph 70 is important because in paragraph 70, it expressly disavowed the notion that it had to ask the question for itself. So paragraph 70, it said in terms, having set out the UNHCR's evidence, it said that that is not the question we must address. The question is, notwithstanding the opinion of the UNHCR has now expressed, there are points about now that Sir James doesn't take anymore, he took them below. The Home Secretary was entitled to hold the contrary opinion. Now, that isn't explicable by the notion that the language of entitled is a capacious notion, broad enough to encompass we are the decision taker, we are allocating weight, and the ordinary connotation of that term, we're exercising a judicial review function, because you've got the negative here. It negatives the idea that it's asking the question for itself. That is not the question we must address. Not addressed, as I said, with respect to Sir James's oral submissions, his written submissions, or in the Lord Chief Justice's dissent. And then, even assuming, the second point I wanted to make, even assuming against us that it did ask the question whether the Secretary of State's conclusion was correct, assume it asked that question, applied a correctness standard to the Secretary of State's conclusion, that wasn't enough. The Master Rolls was right repeatedly to focus on the difference between the court asking, is there a real risk, and asking whether the Secretary of State's conclusions were correct. See, for example, 37 of his judgment. And that isn't simply an abstract point. There's an important temporal issue here. The Secretary, one has to ask, when was the Secretary's assessment made that the court supposedly was agreeing with? Was it when the policy documents were published, 9th of May? Was it when the decisions were taken on the 5th of July? Was it when the latest evidence came in? Assume against us it's the last point. What you still don't have, what the Secretary of State still doesn't have considered, is Mr. Botnick's third statement. There's no response to that. And that isn't just dealing with trifling issues. That's dealing with the 34 cases of cross-border chain refoulement and some pretty startling accounts of abuse by the DGIE. The court has that. The Secretary of State doesn't consider it. There is one statement which succeeds Botnick 3, and it's Armstrong 5, submitted on the first day of the hearing before the divisional court. And all that is directed to is saying, we've now got a monitoring committee. We've now got members of it. We've got terms of reference. I think there weren't even terms of reference until the 5th of September. But the point for present purposes is there is no response to Botnick 3 by the Secretary of State. So even assume that the court is agreeing with the Secretary of State's conclusion, the point that the Master of the Rolls alighted on has real purchase because of the temporal issue. And then the fifth point I wanted to make is the point of substance. If you look at paragraph 53 and compare that with paragraph 55, it's very revealing. Paragraph 53, the court sets out some of UNHCR's concerns. With respect to it, it does not set them out fully or accurately at all. There are some fairly significant failures, but never mind that's my 1B point. It then says at 55, it isn't necessary for the purposes of this judgment to address every such point. The critical word being addressed, not resolve, not conclusively fact-find upon, but even address. And that suggests, as Lord Justice Underhill said at 270, that it was approaching its task as a review function rather than a ask the question for itself function. And the last point I want to make concerns post-judgment reasons. The Secretary of State relies at paragraph 24 of her case on the Greenwich case. That concern, if you want the reference in your bundles, it's page 5673. Please don't turn it up. The alleged error in that case was a failure to give reasons. Lord Justice Jackson held that further reasons could be taken into account in that context. That is different to the situation that we have, because we have an alleged misdirection of law. That falls to be assessed on an objective reading of the judgment. The divisional court's subjective reputation, if that's what's being suggested, is neither here nor there. Secretary's case at 26 seems to suggest that. The points that the divisional court made in its consequential judgment, that we misread the judgment, we took one sentence out of context, that lawfully reach is consistent with finding discharging the article for yourself for yourself. Those are either good points or they're bad points, but they're not extra good because it's the court that's making them, because you've got to read the judgment objectively. There's a lot of authority on that, of course. So those are my submissions.
Were you going to say anything about paragraph 63 of the divisional court's judgment?
Yes, 63, the point that Lord Hodge made, that it sets out what it's got to do. that we respectfully submit it doesn't do it. It doesn't discharge that task. Sandwiched between 63 is 62, two references to entitlement, 64 immediately succeeding that passage that Lord Hodge drew attention to, entitled to rely. And then we say that standing back, the errors were pervasive, and there really is no answer to the 2 points I made. Mr. James's notion is that this is capacious language and can deal with different models of challenge. But that doesn't address 70, where the court expressly says that's not the question we must address. The question that this demonstrates the risk, that the UNHCR material demonstrates the risk. It doesn't address that. And then it doesn't address the temporal point I made.
But in 70, what the court was doing was comparing UNHCR's previously published views with Mr. Botanick's statements, which they considered inconsistent with those views.
Yes,
and it seems to be that they're saying, well, we don't need to go there and balance the two out. I wonder if you're reading too much into 70. And also, to understand the expressions in relation to entitlement, don't we have to go back to 44 and 45, where at 44, the Suring submission at the end of the paragraph is stated by the divisional court, and then they say, although the legal argument was put on various different bases, all converge on two issues. And the second issue, I think you can fairly say, is potentially wrong, or at least ambiguous, whether the Secretary of State could lawfully reach the conclusion that the arrangements governing relocation to Rwanda would not give rise to a real risk of refoulement. Now, there does seem to have been an attempt by the divisional court to create a composite question covering both Suring and
Yes.
judicial review.
I think the critical verb for our purposes is converge. They converge on that. Then it's not just one lawfully reached. This is the point I was making about true reasoning. It's not that you've got lawfully reach here and lawfully reach in the conclusion, but throughout the substance of the reasoning, you've got the court doing the job for itself. The contrast between the passages on this, the refoulement question, the system question, the asylum system question, and 73 to 77 is striking. You haven't got anything like that in 77 to 73. And I don't accept, with great respect, my Lord, your approach to paragraph 70. Not only is that apparent tension not raised by the Secretary of State anymore, it's certainly not in his in her written case.
Well, it may not be, but that's how I read it.
No, I accept that. That's not, yes. But my Lord, the question that they're addressing is not the conflict question. The question they're addressing is whether Rwanda, if you look about 5 lines up, Rwanda could be relied upon to comply with its obligations under the Refugee Convention. That's the question that they're rejecting the relevance of, and that is exactly what Lord Justice Underhill thought as well. In paragraph 129, subparagraph 4.
Thank you.
Presumably, I mean, if I'm following you, you would say that neither of the issues identified in paragraph 45 is a correct formulation of the Suring issue.
I would say that, absolutely. Yeah. And that was also the Master Rules view.
That was the Court of Appeal's majority assessment.
It
Yes.
was. But you've got all of that, and then the 2 points that I've said now, I think, I'm going to repeat it, would be the third time, the 2 points, temporal point and my approach to paragraph 70. I appreciate my Lord has a difficulty with that. But those are the points. Can I please move on to ground 1B, unless there's anything else on ground 1A, as we put it, the misdirection issue?
I mean, I'm just thinking it through, just for a moment. This morning, Sir James opened his submissions by saying, at heart, this is a case about the judgment made. But this case is about the judgment made by the government about the conduct of a friendly foreign state. Essentially, the government's answer to all the issues raised by the claimants is these matters are addressed in the MOU, and the Secretary of State's assessment that they're satisfactorily addressed is one that the courts ought to respect. And one can see, if you put it that way, then the soaring issue can be said to boil down to, might be thought to boil down to a judgment of whether the Secretary of State was entitled to form the view that Rwanda was a safe country based on the MOU.
Yes.
But you, I imagine, would say that that assessing whether the Secretary of State could reasonably form the view that Rwanda was a safe country is not the soaring test.
We would absolutely say that. We would accept. What you've got to have is a court performing the task and allocating weight as appropriate. So James's submission is, well, that's what entitled can be stretched to mean. The normal meaning of that is that it's regarding somebody else as the decision maker. If I think that X is entitled to do something, I think that's within his or her province. Be that as it may, paragraph 17, the question they say it's not for us is the question of whether Rwanda can be relied upon to discharge their obligations. And then you've got a temporal point. I'm sorry, I don't want to keep repeating myself.
Well, I want... you say that's the question in 70. That's not how I read it, but I have your submission. But anyway, in 73, the court also says the final matter to consider in respect of these grounds of challenge is the wider Serling submission. So this is presumably a statement in the context that they consider that they've been dealing with a Serling submission already.
Yes, I respectfully submit 73 to 77 cuts both ways. So James can say, look, isn't it remarkable they asked that question for themselves, didn't in the earlier context. I can say, when they are signalling that they're asking a question for themselves, they make it clear. I wanted to move on to one maybe that you'd like to break. I'm very happy to make a start.
Well, I think this is perhaps, is this a convenient moment for you to adjourn?
It is. Yeah.
Oh, well, in that case, we'll adjourn for the day and resume at 10:30 tomorrow.